I am going to address some of the biggest questions that you have about estate planning, some of the biggest concerns that you have about estate planning. During our design meeting, our free initial consult, we will address these as they may pertain to your situation. So people come to us all the time. They say, Mike, what's the difference between a will and a trust? We'll talk about that during the meeting. Some of the biggest high overview points are a will is public, goes through the probate courts. In Texas, you have to have an attorney help you. A trust is a private document, should stay out of the probate courts, does not necessitate an attorney helping you, though you can decide as trustee to hire an attorney. So those are some of the biggest things. Do you own multiple properties, property out of state, LLCs, have young children? Those are things that typically push people over here to a trust, but not everybody needs a trust. Not everybody wants a trust. So we'll talk about those differences as they may pertain to you and your specific situation. Children's guardians. Now, this is one of the big things because a lot of people say, I have been trying to do this forever, but I just can't figure out who to name to raise my children if something happens to me and my spouse. We make it simple. If you don't do anything, the state has a plan for you. So let's put your plan in place and we make it so simple. We do those guardianship nominations outside of the will. So they're super simple to update if you have a change of mind, want to change those documents. So we make that simple for you. How to avoid probate? A huge question. The biggest thing to understand is no attorney, no person can guarantee that they will stay out of probate because there's different things that could push probate. Oftentimes there's an orphaned account. Someone does a trust, they do beneficiary designations, but there's an orphaned account. There's something they forgot about this bank account over here. They're like, oh, it's only got like $3,000 in it. Yeah, well, now it's orphaned because it doesn't have a beneficiary. It's not owned by your trust. Doesn't name a person as a co-owner to take it over with rights to survivorship, and therefore that can trigger probate. You may forget to have your LLC properly titled, and so it can trigger probate. A creditor can trigger probate, but we can set you up for the best possibility of success of staying out of probate, the highest probability, based on how we structure that plan. Do we do a will with transfer on death and payable on death situations, deeds, beneficiary designations, etc., co-ownership, joint tenants with rights to survivorship, different things to think about. How real estate triggers probate. One of the most surprising things, and I think, based on my experience, what causes probate more than anything? Well, an orphan account and a house. A lot of people say, well, my spouse and I own our house together, so I'm just going to get it. Well, in Texas, the default is typically tenants in common, not joint tenants with right of survivorship, and therefore, when one spouse dies, their estate owns it, not the surviving spouse. Now, the estate may, based on state law or their will, go to the surviving spouse, but it's got to go through that probate process first, typically. So you got to make sure that you have that set up properly because most people get that wrong, unfortunately. How probate can destroy LLCs. So you've got this LLC, you've got a business, you've got employees, you've got bills, and you pass away, and there's no one else who can go in and manage the bank accounts because you didn't set it up and designate it as such. There's no other officers with that authority, etc. You pass away, and now you're trying to write checks. You're trying to do stuff with bank accounts, investments, and that person doesn't have the authority. So you have to wait for that will to go through the probate, maybe 2 months, 3 months, 4 months, 5, 6 months, whatever, depending on the state, maybe even longer. And they can't do anything with it. So you've got this situation where you can't write checks to pay employees. If you don't have employees, you can't pay your employees, they're probably going to leave. If you don't have employees, your clients are probably going to leave. And now your LLC that may have been worth $5 million, $1 million, 100,000, whatever it is, might be worth a lot less, maybe even near zero, maybe less than zero. So you want to make sure that your LLC is properly set up to transition smoothly, efficiently, quickly upon your passing. How to stop procrastinating. This is a huge thing. People say, Mike, I should have done this decades ago. I should have done it 30 years ago, 20, 10 years ago. I should have done this 40 years ago when we had our first child or whatever it is, right? People procrastinate for a couple of core reasons. One, they don't want to think about that. No one does. But it's guaranteed we are going to die and take our last breath on this earth at some point. So go ahead and be prepared. Otherwise, the state's going to have a plan for you. Another reason people procrastinate is because they don't want to take the time. They spend all this time trying to plan a vacation and no time trying to plan their final destination, their final vacation, and what's going to happen with their life savings. And then some people just say, you know what, I haven't wanted to spend money. I prefer to spend it on this new car, this new boat, this new trip, but I don't want to get my life savings plan in place. Again, I understand the procrastination. But how can we help you get over that procrastination? That's what we do as a firm. We have this very simple process. It's simple, it's smooth, a 3-meeting process. You have a design meeting where we design it, a review meeting where we review it by Zoom typically, and a signing meeting where you come into the office or sign remotely. Most people come to the office and we sign the documents. So we have a smooth, efficient process to get this done so you can get that weight off of your shoulders, get your life savings plan planned for, get that taken care of, right? And we do it at a very competitive fee. How much do you charge? We have flat fees that are transparent upfront. During that design meeting, we will tell you exactly what your fee will be. Exactly what your fee will be. So just go to book the design meeting. There's no charge for it, no obligation. It's $0. We will talk about your situation and tell you exactly what it will cost, because everybody's situation is so different. Someone who just has a house and a piece of property, or I'm sorry, an investment account or bank account, is different than someone who has 5 pieces of property, or an LLC, or a couple LLCs, or properties out of state, or minor children, or inherited money, or separate property, or blended family, right? Every situation is different. So we will be able to tell you on that call the exact price of the estate planning for your situation. So if you haven't already, go ahead and book a meeting with it. It's no obligation, 0 cost. We'd love to see if we can help you. If we're a good fit for you and you're a good fit for us, then we'll extend an invitation to work with our firm, in which case we will send you an engagement letter to sign or e-sign, a link to pay our fee, and once those 2 things are received, then we can proceed at that point. Have a wonderful day.